Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we are glad to be here today. If you have a legal question, all you have to do is call the toll-free number, which is 877-943-9673. That's 877-943-9673. Phone lines are open. Your question can be just about anything. It can be about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates, living wills. It can be about family law. It can be about traffic law. It can be about next door neighbors. It can be just about any question. If you have a legal problem, something kept you up during the night, concerned about something, hey, give me a call. I am more than glad to help you in any way I possibly can. And we're here for 50-minute straight run, no commercials, and just here to help you if I can help solve a legal situation or a legal question. Again, the toll-free number is 877-943-9673. That's 877-943-9673. Lines are open, and we are here to help as many people as we possibly can. All you have to do is to call that number. You're listening on multiple stations around Florida today. We're broadcasting from Tampa today. So you're listening on that network of shows, the 570, 910, 860, 930, Salem Family. You're listening in Sun City Center, perhaps, on 96.3 FM, the local community station there. And also, I think it's 100... I can remember the FM signal, but they have an FM component too. I think it's 101.1. But anyway, you're listening, so great. And also, you might be listening on 96.3 FM coming out of Haines City. I'm sorry. That's the I can't remember the signal now of the FM station in Haines City. I think it's 90.3. But anyway, you're listening, so that's great. You might be listening in Jacksonville on WBOB 600 AM, The Answer. And if you are listening, great. You have a chance to call in. You have a toll-free number, 877-943-9673. Phone lines are open. A lot of questions we get are about estate planning, which is one of the firm's primary practice areas. So if you have a question about estate planning, probably the most often asked question is, my out-of-state will good? I reviewed a will today that was, not today, I reviewed a will this week. Actually, it was a trust that was signed by the person and notarized, but not witnessed. It was from another state. So the question becomes whether or not you can, that would be a valid Florida trust. And the answer is you couldn't put the Florida homestead into it. And the reason why would be because it wasn't witnessed. It was just signed and notarized. I mean, it was signed by the person and notarized by the attorney. So it would have to restate the trust to make it a valid Florida trust to be able to put real estate in it. So there are a lot of differences from state to state on how things are done. If you move to Florida, you need to I would definitely have your trust reviewed, possibly modified to work better in Florida. And if your will is not notarized, so some wills are reviewed just signed and witnessed, it would be a valid will, but if it's not notarized, it doesn't become self-proving. Updates should be happening every 3 to 4 years, reviewing things, making sure it all going to work. But if you have a legal question, you have a toll-free number. It's 877-943-9673. If you're listening, you give us a call. We'll be more than glad to answer your question. Your question does help a lot of other people as well. And phone lines are open right now. I'll be more than glad to take your call. I come in just to help you and answer legal questions. Really don't have a script prepared, just to talk, because we usually have the lines fill up and answer your legal questions. Again, toll free, 877-943 9673. One of the questions that I had this week was concerning whether or not who can serve as a personal representative of a will. The will can the personal representative has to be a blood relative. Okay, we do have some calls here. So, blood relative or a resident of the state of Florida or the spouse of a blood relative. Let's go to our first caller and go to Tom calling from Davenport. Hey, Tom.
Hi, good morning. I am a lien holder on a car title. Do I have any liability if that car is in an accident?
Yes. Well, lien holder. You're not an owner. You're
not an owner. My name does not. My name appears as a lien holder only.
No, just because you have a mortgage on it and you're a lien holder does not. You have to be they sue the driver and the owner.
Okay.
So that's the general rule.
Okay. Thank you for answering the question.
Thank you.
Have a good day.
Thank you. The WLVF in Haines City is 90.3 FM, by the way. So I think I had that right. Let's go to Alan in Jacksonville.
Hello. I have a question and asset protection question. I have maybe a little bit of a mixed bag of how different accounts are titled. What is the best way to title an account for asset protection?
Well, what is the item, a homestead?
No. Let's say you have a savings account.
Are you married?
Yes.
Okay, so if you own husband and wife together on an account, that's called tenants by the entirety. So there's tenants by the entirety, there's joint ownership with right of survivorship, there's tenants in common, there are different forms of ownership. So if you own it, husband and wife, tenants by the entirety, they'd have to be able to sue both of you to be able to get to the asset. That's a special category of protection.
So you would set that up at with the bank or whatever?
Yes. To
be titled that way. Now, does it matter if it's in a trust?
That's a great question, and I'm not sure it's been tested in the court. My thought is if it is jointly held between husband and wife, even if in the trust, it's still protected it can be still protected under tenants by the entirety.
Okay, so but it being in a trust in itself, maybe anything in a trust isn't necessarily an asset protection device.
Yeah,
only for probate.
The living trust is mainly an estate planning document to avoid probate, avoid guardianship, make it quick, easy, fast, efficient, and private. But the fact that it's in a trust does not give it any additional asset protection. Now, if you ask me if I could create a trust that would be totally asset protected, you could create an irrevocable trust. But then most people don't do that because then you restrict yourself on how you use the assets.
I got it. Okay, that answers my question. Thank you very much for being there.
All right, thank you. You're listening to Ask an Attorney all about Florida law. If you have a question to call in today, you have a toll-free number, which is 877-943-9673. That's 877. Phone lines are open, 943-9673. Glad to be here. Hope I can help you. Let's go to Dan in Jacksonville.
Good morning, Joe.
Good morning.
Thank you for your show. I've got a trust. It's dated 2002. I'm down to just one surviving sister, and I have a great friend out in Texas, and my sister lives in Ohio. So I need to update my trust. And my basic question is, and I've never been married, don't have kids, never had kids. I got 3 pets, if that counts for anything. But could my trust be set up so that you, Joe Pippen, your office, whatever, is the trustee, and you just handle everything. You sell my house, you close my accounts, my IRA, you settle everything. And then if I still have 2 survivors, my sister being one and my friend in Texas being the other, they get their fair share. And if they're not around, then you distribute it to whatever charities that I would want money sent to. Is that possible?
Yes, sir.
Okay, and then
we provide that service for our clients who request that we do. So your choice,
so then,
Go ahead.
Okay, so in the case of my property and I have a couple of IRAs and whatnot. You have people that you just hand the ball off to, and then they're familiar with the process, and they just go ahead and get everything finished. Then.
Yes, sir. Yeah, and if I'm the trustee, I'm doing it. I'm doing that myself, of course, with help from the staff, but I am doing that myself. So.
Okay, and then one kind of silly question, if it's silly. So in the case that you retire or God calls you one day, I assume you've got some kind of a setup where other people just take the reins and handle the rest of your business.
Yes, I have a succession plan worked out in my firm. Yes, sir. And we
All right.
so we have over like 53,000 files right now in estate planning. So the firm's definitely going to go on, well past me. So we've got to figure out who's going to be in charge of that.
Okay, so I just need to get my button gear, and then I'll get an appointment set up. And can I ask you one question regarding my sister that passed away last year up in Ohio? She died of ovarian cancer, and she made one discouraging remark about baby powder. And so we've all seen all these commercials on television for different attorneys across the country. If you taken baby powder or lost somebody, call us. Is there any validity to all that, or is it all just a bunch of smoke and mirrors? No,
I'm one of my clients is having a lawsuit right now against one of the manufacturers, Johnson & Johnson, about a wrongful death in that case. So that's something else we could talk about as well, perhaps.
Okay, that's something I probably would consider then. I mean, not that I would need any money or something in a lawsuit, but I don't know how that world operates. Okay, so I will get my button here. I will get on your website.
Okay, I'm in Jacksonville every other week. You can just call the toll-free office number to make an appointment, which is 800-226-3529.
Do you meet on what day of the week do you meet? Fridays or Saturdays or what?
Usually when I come to Jacksonville, it's either Thursday or Friday. Mm-hmm. And I'm there every other week. I do meet people. Right. They can't meet me on Thursday or Friday. I do meet some people at the radio station on Saturday morning right after the show there in Jacksonville every other week.
Okay. All right. Well, then I look forward to meeting you.
All right. Thank you. Looking forward to meeting you.
Thank you, Joe. Bye-bye.
Let's go to Greg in Middleburg.
Hi, how are you?
I'm doing great. I know exactly where Middleburg is, by the way.
Congratulations, one of the few.
Yeah, well, we drive from Tampa every other week. Go from the Tampa area to Jacksonville. So we go through Gainesville, and drive right by Middleburg. So.
All right, 301.
Yep. What can I do for you?
Granddaughter's a trust fund baby. She owns a house free and clear. Has a fiance and 2 children. She's 21. He's 20. Insurance is killing him. Auto insurance. They said if he can prove that he's part owner in the house, they'll cut his insurance by $150 a month. Any issues with that other than just doing a quick thing to read on that on the title?
No, this is not a homestead, is it?
It's where she lives. I'm not sure the legalities of homestead.
It's where she lives, so that's her primary residence. So there are a couple of things. If he's going to live there, then they could both have homestead. If she transfers it to him, put his name on a quitclaim deed, it's a gift. So the value of the gift, if it's more than $15,000, and assume it's real estate that it is, she would have to file a gift tax return. She would not have to pay a gift. She could elect not to pay a tax and use up part of her lifetime exemption, which is $11.5 million. But there's a formality that she would have to go through of filing a gift tax return because she gave away more than $15,000. And then if he moved out, she wouldn't have the full homestead exemption. So there are some negative things about gifting real estate like that.
Right. Just to save money on auto insurance.
Yeah. So I would probably, if she were my client, I would probably tell her not to do it. I'd explain all this to her and definitely give her the something to think about whether she should do it or not. Maybe I should say it that way.
Okay. Well, they'll be selling the house before long anyway and moving out.
Well, if his name is on there, then she'd be splitting the proceeds of the sale with him too.
All right. So they're still living together. It's not an issue. They're just not married yet.
I'd tell her, my advice probably would be, not knowing any more than I know other than what we've talked about, is don't do it till you get married.
Okay.
All right.
Appreciate it.
All right, thanks. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. If you have a legal question, you have a toll-free number, which is 877-943-9673. That's 877-943-9673. Phone lines are open. Let's go to Elwood in Intercession, Florida.
Yeah, I got a question. I am on Social Security, and I need I don't know if I need a will or what. The only will I have is on an app on my phone. It was a video. Is that legal?
No, that by itself would not be a valid will. So,
well, the thing is, it's me on the video saying what I want, so that's not legal.
Has to be in writing and signed by two witnesses in the presence of each other, and it'd be helpful if it was notarized. So that just a video is not a valid will.
Oh, okay. Well, I thought it was legal, so I thought I'd ask you.
Wills are not that really expensive, so do it properly and sign it in front of two witnesses and a notary. We charge like $150 for a will, and then you have peace of mind that it's a valid will. Just a video will by itself is not a valid will.
Kind of breaking up here for some reason, but you did answer my question, and I appreciate what you're doing, and God bless you.
God bless you. Hey, you're listening to Ask an Attorney. I'm Attorney Joe Pippen, practicing attorney. And if you, I'm celebrating 40 years of practicing law this year. 40 years. I got an email from somebody trying to sell me a plaque, about celebrating my 40 years on it. It's got me started thinking about it. So I started practicing in 1981. And actually, I've hosted Ask an Attorney all about Florida law for 37 years. So most of my law practice, I've done a radio show every week, about celebrating 40 years of legal practice. And I definitely want to be celebrating 50 years of legal practice, just to let you know. But anyway, you're listening to Ask an Attorney all about Florida law. I'm Attorney Joe Pippen. You have a toll-free number, which is 877-943-9673. Phone lines are open, 877-943-9673. And you're listening to Ask an Attorney, a live show where you can call in and ask legal questions, something I can help you with. That last caller now, a video will. Video wills are only a supplement to your written will. And if you have something on video, that's not enough. You really need something in writing. So a lot of people will supplement a living trust or a will with a video. Now, it can't be different than your written document. And you can't make changes just by doing a video and saying, well, I left you all 3 equal shares, so now I want to give 10% to the church or Salvation Army or SPCA. Y'all take care of that for me. That's not a valid document. A video is not a valid document to change a will. And if sometimes we discourage videos because if a person is elderly and has a hard time speaking their thoughts properly, or they're very, very slow, and maybe someone is helping them what to say during the video. That can all be sometimes more harmful than it can be helpful. So video, if you want to do a video presentation of what your will says, that's great. Just make sure it's consistent with the will itself, or you're just possibly creating a problem. You're listening to Ask an Attorney, all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. You have a toll-free number to call the show, and I'd be more than glad to talk to you. About halfway through the show, 877-943-9673. That's 877-943-9673. Some people like to do a video that explains why they did something. I admitted you, John, my son, because, and they list a reason. Well, when I'm doing wills and somebody gets omitted and we discuss the reason, I usually say, look, I just want to put in your document that you've omitted John for personal reasons, period. I don't want to put in the document and spell out a reason. Because guess what? John would say, that's not true. If they only omitted me because of that, that never was true. And they argue that no, that wasn't, that their request of them was invalid because of that reason you stated it wasn't true. Better just to say, I've omitted so-and-so for personal reasons if you want to omit someone. All right, let's go to Donna in Cocoa Beach.
Yeah, hi.
Hi.
I have a house that's going into foreclosure, and it has like $300,000 equity, and it's a new mortgage company that took over the other mortgage company, and didn't give me notice, and they said they're foreclosing, but they won't give me any workout plan. But it's actually them that's selling it, and I can't seem to get any help.
Well, get a good realtor to list the property for sale. Have an attorney write them a letter of their properties for sale, and the attorney can try to stay or suspend the foreclosure procedure. They aren't going very fast in the courts anyway. But first, I think the first step would be to get a realtor. Real estate is selling so fast today. Properties don't stay on the market very long. And most real estate agents, if you talk to them, they'll tell you they can't keep inventory of real estate because everybody's buying up real estate very fast in Florida, and things when they go to get listed, they don't stay on the market very long. They're taken. And there is definitely a way to put everybody on notice that the property's for sale in an effort to stay or suspend the foreclosure proceeding.
What if you have someone on the title that's not you, that shouldn't be? There's a problem. There's a title dispute that's been in battle.
Well, you do a petition of lawsuit to quiet the title to resolve the issue.
Okay, I've heard that before, to quiet the title. Okay. Yeah. All right. And then, okay. All right.
All right, Don, I hope all that works. Hope you sell your property. All right. All right, thanks.
Bye.
Phone lines are open, 877-943-9673. Let's go to Jimmy in Newport Richey.
Good morning.
Good morning.
Yeah, my question is, I have a property, a house I bought for my parents, and I moved them down. They're in the property. Put it into their name for help for homestead exempt.
Mm-hmm.
And, we went to fill papers out to, something were to happen to them, then it would come straight back to me. I do have other siblings, and I think my only concern would be is if they feel like that was my parents' house, that they could come after, whatever.
Well, what kind of papers have been filled out so it comes back to you? What did you do exactly? Is a land deed, a life estate deed?
I think it was a life and estate deed, where I'm really not 100% sure which one it is. We went to an attorney to fill out the will and all that stuff.
Mm-hmm.
And just wanted to maybe, I don't know, if I get your information, I can double check all that and make sure it's the right paperwork.
Well, if they did some, it sounds like they did what's called a ladybird deed, to where they own it while they're living and they put a remainder on the deed that goes to you. And if that's all done properly, that would work. And they wouldn't, the other children wouldn't have any say. It would be your property.
The house was paid off.
Yeah, the only thing I heard of some concern would be that if you went with them when they did all this, they would have an open door to argue undue influence. But
You mean my siblings?
yes.
Okay, no, it was just my wife and I and my parents. Who was the only ones that signed the paper.
Yeah, no, but that's you were with them when they gave you the property upon their death, basically.
Correct.
So a sibling could argue that was undue influence because you were present when they did that.
So
Here's the
Okay,
example. Here's the example. Some a child brings a parent to my office, and they have 3 children, and during the meeting, the parents do a will or try to do a will or trust to leave everything to this one child that's with them. I won't do the document that day, because that opens the door for the other siblings to argue undue influence. So I politely explain the whole circumstances, and most of them, and I say the best way to really do what you want to do is to come back, parents, come back on your own without your child present, because your other siblings or your other children are going to argue that he or she unduly influenced you while you're here today, and you brought him here, and you're sitting here in the office with them, and they're doing a document leaving it to you and not them. Well, that's undue influence, and most of those arguments get won. So if I can talk the parent into coming back at another time without the interested party, most all of them do that, because it's going to be more peace of mind and a lot safer in the long run.
So even though the property was mine and I purchased the property and then put it in their name, that still could be an issue?
Could be. I mean, that's a good argument of why they wanted to give it back to you. But I think it would have just been safer if you hadn't have been there when they signed the ladybird deed, giving it back to you upon their death.
Okay.
That's something you could discuss with the attorney. Hey, discuss it with the attorney that did the transaction, and tell him you talked to an attorney on the radio, and the attorney expressed a little bit of a concern about that, and whether the attorney has any concerns about that, and see what they say.
Okay. I sure appreciate your time.
All right, thanks.
All right, thank you.
All right, you're listening to Ask an Attorney All About Florida Law. If you have a legal question, you have a toll-free number, which is 877-943-9673. Hey, we are broadcasting video live today on WeBeam TV. So WeBeamTV.com. You could go there and check us out. You could also, we're also, in addition to that, at the same time, it's going live on Facebook. So you can find us on Facebook, perhaps on a live stream right now. If you'd like to connect with me on Facebook, we have Law Offices of Joseph Pippen page. We have an Ask an Attorney page, and we have a Florida, my home page. We also are on LinkedIn. Sure, you can find me on social media on either Facebook or LinkedIn. We also have a YouTube channel of some of the shows, and we've done some Zoom seminars on a lot of different topics. You find all that on our YouTube channel. Just look up Joseph Pippen. Be glad to connect to you in any of those forums. Let's go to Bill in Tampa. Hey, Bill.
Hi.
What can I do for you?
Oh, okay. I have an easy call. My mother-in-law, she has dementia. We got her in a home that she's in Arizona, and we have all of her mail forwarded to us out here in Tampa. And we came across, she owns 2 lots of property out here in Florida. We find out that she's got, she hasn't paid property taxes on this in like 7 years. And so we're like, okay, we need to take care of this because it's not in foreclosure or anything, which kind of surprised me. So we're going to pay the property taxes, but my wife's got a brother who says she can't pay anything. So I'm like going, what would I do if I pay the property tax in order to make sure I get the money back?
Does somebody have her power of attorney?
Well, my wife does. Well, we have the durable power of attorney.
Yes.
From Arizona, so.
Mm-hmm. Well, I would see if your wife you talk to a real estate agent to list the property. I could probably refer one to you and see if they'll accept the power of attorney as her power to be able to sell that property.
Okay.
Usually there would be a clause in there where you can sell real estate with the power of attorney.
Okay.
If your wife sold it, though, then the liens would be paid off, and then the residual check of the equity portion should be made out to the mother. Does the power of attorney? I'd have to review the power of attorney too. Does it give the power to create a trust? And does the mother-in-law have an existing last will?
She has a will. She a trust.
See, the power of attorneys I do, for example, for clients now, have a provision to where you could take an old will for a person who no longer can make a will. You can turn that into a trust. You can attach the copy of the will as the distribution plan, and you can use the power of attorney to create a trust to put the property into avoid probate upon death.
Okay.
So, but I would need, in this case, I would need to see the power of attorney, and then I could also, if you didn't have a realtor, I could also help you find a realtor to get something done about all this.
Okay, cool. It was contemplating, thinking about keeping the property as well because it's property.
Well, you can't really use a power of attorney to benefit yourself, though.
Okay.
So I don't know. There are a few little issues like that need to be discussed out and work out a plan.
Okay, yeah, I didn't know if we paid the taxes, if it would be like just put a lien on the property as a,
Well, it seems to me strange that the property taxes have not been paid for 7 years without the county doing something about it. Usually they would offer a tax deed sale. So somebody may have already, so that needs to be looked into also as to what's going on with that.
Yeah, I was looking online and I saw some taxes sold to collections or somebody else.
Well, that's somebody's been paying the taxes and basically has a lien on the propery.
Okay,
Sooner or later, their property will go on sale on an auction type of deal.
Yeah, and that's what surprised me that it was still there, because when we got the letter forwarded to us, we're like, wait, what?
Yeah.
You have property in Florida?
No.
And, now she's at home, so we're trying to be protective of her out there.
Okay. All right. Well, if I can help, I'd be glad to.
Okay, great. Thank you. And just give me a call and stuff like that.
Yeah, my toll-free number for everyone listening is 800-226-3529.
Okay.
All right, Bill, thanks.
Thank you. Thank you.
All right, thank you. Let's go to Amanda in Jacksonville.
Hi, good morning.
Good morning.
This is a little complicated. Due to COVID last year, I didn't have a lot of income. So I lived off of credit cards, which I'm sure a lot of other people did. In the meantime, because of that, I have never gone without car insurance. So I got paid on Friday. Thursday, I didn't have car insurance. And, of course, I got T-boned. So now we have the credit card debt and we have the car, which is a lease. So I'm really stuck here, for lack of a better word on the radio. So I'm going to claim bankruptcy. And I did speak to an attorney. He said that claim bankruptcy first, and he would give me, which is very, very expensive, and you don't have any money, ironically. Claim bankruptcy first, then he can give me a list of places to get another car with bad credit. My question, should I claim bankruptcy and then get the car, or should I get the car and then claim bankruptcy? But I mentioned this was a lease.
Well, if you can get the car, is the car going to have any equity in it? It sounds like to me, it seems like to me the attorney told you to do the bankruptcy first, right? And then he had some sources that you could get a car even though you had filed bankruptcy. Is that what the attorney said, basically?
Yes, sir.
Well, I think I'd just follow his advice. I mean, I wouldn't want to counter his advice. If he's got the resources to where you can get a car after you filed bankruptcy, then you trust this attorney. I'd roll with what he suggested, because if you bought the car before bankruptcy, it seems like now you have an asset, and if there's any equity, you're going to do a new lease though, right? So there's really no equity in a lease.
Well, see, that's the other question. Do I lease or do I buy? Because if I buy and then claim bankruptcy, I don't want them coming out for the car.
Yeah, exactly. Well, that's why he suggested you do it afterwards. So I guess I'd probably flow with his advice if I were you. His or her advice, whatever the case might be.
So, in your expert opinion, I wanted to get a second opinion because I don't know this guy. You know what I mean? So claim bankruptcy, then.
Well, I wouldn't buy a car, then do bankruptcy, because then the car is whatever equity can be. You can sell the car for the equity to pay off the creditors. So it sounds.
If I leased it?
If you lease, there's no ownership. You know. You got to have money after the bankruptcy to keep making the lease payments, though.
I will. I mean, I pay the basics. I have money now to pay the basics. You know, the rent, the electricity.
All right. So I have a bankruptcy attorney on my firm that probably could spend a little bit more time with and see if he comes up with the same suggestion. If you haven't hired this other attorney, you can just be seeking more information. So if you want to call our office, the number you're calling from Tampa, so 727-586-3306, and go to extension 116. That would be Jim, and he does some bankruptcy cases. He can talk you through it as well.
Awesome. Thank you so much.
All right, thank you. All right, thank you.
Okay. Bye.
Bye-bye. Phone lines are open. We have about another 10 minutes or so. If you'd like to call the show, you have a toll-free number, 877-943-9673. Phone lines are open. Let's go to Karen from Jacksonville. Hey, Karen.
Good morning. My ex-husband passed away over the holidays, and everything has been left to our two children in his will. However, his house and car, I'm told, cannot be given directly to them. They must go through probate. And we don't know anything about how to go through probate or what's involved. And if they need an attorney, they're both unemployed at the moment. So we need to figure out how to do this in the least expensive way to do it.
Well, do you know what the house is worth?
Rough estimate of maybe 175, 200.
And are they going to keep the house, or are they going to sell the house?
Well, my son's going to go ahead and move into it.
Okay. Well, you know, if the house were sold, you'd have money to pay the attorney, of course. So if they want to keep the house, just keep $175,000 asset and have no money to pay the attorney. I'm sure that we work out arrangements, you know, with people to pay us on probate, and we do probate. But we'd also like the expectation of, you know, where is the money going to come from to pay us? And usually if they can't pay with their own funds and there's no cash in the estate to pay, the question then becomes, how are you going to pay us if we're going to do all this work and give you the house and you have no money and are not employed and there's no cash in the estate? How do we eventually get paid? So, I mean, that would have to be worked out. But we do probate, and we do work with people who can't pay us, that, you know, but we need a plan of how they are going to eventually pay us. Where's the money going to come from? Does that make sense?
So there is no. Yes, I understand.
Okay.
So when someone passes away, there is no alternative. It must go through the probate court.
Yeah, if there's
And in order to do that, you must have an attorney. It's not something you can do on your own. Is that correct?
Well, you could do it on your own, maybe if you knew how to do it. But if the largest law book I have is the book on probate. It's a lot of things that have to be done. And a lot of people have tried to do it themselves and come to me and they mess it up even more than it was to start with, and they try to do it themselves and they fail. The largest percentage of people that have tried to do it on their own get caught somewhere with some issue they didn't know or can't do or didn't do, and gets kicked back, and then they finally give up and come to an attorney to try to do it for them. Were there creditors involved in the estate?
No, there were no creditors.
Well, a home.
And I understand that whatever other assets he had, as far as a bank account or any stocks he might have owned, the fact that they were beneficiaries on his information means it goes directly to them. It need not go through probate. Correct?
Have they already collected those assets, though?
No, we're still waiting to get a copy of the death certificate.
Well, see, if they had money like that, then they would have money to pay the attorney when they get the death certificate, right?
Right.
Okay.
If there's enough there, yeah.
Yeah. So, yeah, I mean, I'm sure something could be worked out. Most likely, if there are no creditors, it became a lot easier to do because you can do a petition. Probably take it through, if the only asset is homestead, can probably take it through what's called a summary administration if there are no creditors. In the automobile, they can usually take a death certificate. Was there a will? There was a will that left it to the two, or no
Yes.
will? Okay.
Yes.
So usually the two of them can take a death certificate down to DMV, Division of Motor Vehicles. And the car, a lot of times the car doesn't go through a probate, and DMV will transfer the car to them right away.
Oh, good. And I heard you mention a ladybird something. I'd like to do that for my house so that when I pass away, they don't have to go through all this. And
Well,
they can directly
I have office in Jacksonville. I'm there every other week. I'd be glad to discuss that with you, the option between a ladybird deed and a trust. My preference would be a trust most of the time, but I can explain all that to you when we meet.
Okay. Good. All right.
And I'll be there this coming Friday. So I mean, you could just call the office and get on my calendar if you like.
I'll do it.
All right.
Okay, thank you very much.
Thank you. All right. You're listening to Ask an Attorney, all about Florida law. If you would like our toll-free office number, it's 1-800-226-3529. Let's go to Sal in Odessa.
Hi, Joe. Lately, there are a lot of ads on TV about companies that provide title security, and it seems like this is a growing threat. I was just wondering how real is this threat, and what can someone do about it to prevent somebody from getting your title in your house?
All right. Well, I said a little bit earlier that I'm celebrating my 40 years of practicing law. I've never had a client come to me with a problem like LifeLock would solve. That's one of the major ones that advertise. Now, I'm not saying it doesn't happen, but these services, and I understand this for last week or so, somebody came in and showed me a notice that Pasco County, you can call Pasco County and they can alert you if there's any change to your title. Now, I don't know if there are any other counties that do that as well, but...
Well, my section of Odessa is in Hillsborough.
Okay. I don't know. I haven't heard that Hillsborough and Pinellas said.
Hillsborough.
You can call them and ask them. But these services like LifeLock are just a monitoring service that you can monitor yourself. I mean, you can go online every day and check the status of your title. But, some people don't want to do that every day and have the money just to have somebody else alert them. And it seems like the counties are getting on board now of establishing some type of alert system themselves. Like I know they do that in Pasco. Somebody showed me the letter. I'm not sure about the other counties yet.
Okay, so it might just be a way to sell services based on fear.
Well, you pay for them to tell you something's going on, and then you pay more for them to be first in line to help you with it. I mean,
right. But when you then just get an attorney.
Yeah, you can monitor it yourself and just get an attorney if you like, and maybe you can. Maybe all the counties sooner or later will follow suit and alert you themselves, which I think would be cool if the county would do that.
Yes. Okay, Joe. Thanks.
All right.
Appreciate it.
All right. Thank you.
All right.
Thank you. Hey, we maybe have time for one more call. Phone lines are open right now, and maybe just one came in. The toll-free number for you to call is 877-943-9673. If you would like to contact our office, I'll go ahead and offer my poster sheet. If you'd like our estate planning poster sheet, or call to make an appointment at the office, the phone number is 226-3529. If you are in Pinellas, Hillsborough, you can use the 727 number, which is 586-3306, extension 200. If you'd like the poster sheet, estate planning poster sheet, it's a bit large, double-sided poster sheet on estate planning. On one side of the sheet, there are like 5 articles on estate planning. The other side has all of our contact information. If you'd like that, I'd love to mail it to you. And you call the toll-free number to get that, 1-800-226-3529, extension 200. If you'd like to get a link to one of our Zoom seminars that we did on different topics. We did one on living trusts, we did one on probate, we did one on Medicaid, we did one on asset protection, family law, did one on gun law in Florida. You can send me an email for the links to those seminars at Joe, Joe, at attypip.com. That's Joe at attypip.com. All right, we do have time for one more call. If you want to call in, 877-943-9673. We had a lot of interesting calls today. Had calls on asset protection. We did a Zoom seminar on that. You could learn something from there. If you want to get that, again, that's Joe at attypip.com. Had a couple of questions on probate today. Probate is the proving process of getting assets out of a deceased person's name. So if you die with something in your name, now it's in and you die, it's in a deceased person's name. Some assets have beneficiaries. They don't go through probate. Some assets, like automobiles, there's a way usually to get the automobile transferred without probate. But if it's real estate or a bank account or stock or bond and it's now in a deceased person's name, no beneficiary, not in the trust, then it's going to go through a probate proceeding. Probate is the legal process of getting assets out of a deceased person's name, where the court appoints and gives someone the authority, the person named in the will if you had a will, the power to go get these assets, pay creditors if any, and so forth. Several questions on probate today. We had questions on foreclosure. Hopefully we gave them advice on how to proceed, because there's a lot of equity in this property that's being foreclosed on. You want to capture that equity, not have it go through a big long legal proceeding where there are tons of costs and so forth. Questions on dementia, how to plan around that, how to do things with people that have dementia. Power attorney is a great tool for that. Questions on security, like LifeLock. Lots of questions. I hope you learned something today on Ask an Attorney, all about Florida law. We're here every week, Saturday mornings at 8 o'clock, right here on the station you're listening to. Every week we're here to help as many people as we possibly can learn more about Florida law, get a little peace of mind about the problems that they have. Again, I'm Attorney Joe Pippen. You can, if you heard something great on this show, the station that you're listening to probably has a podcast, a repeat of the show. If you're listening on 570, 910, they repeat the show on Sunday night at 5 o'clock, just so you know. And also, if you have a Apple, we have an app, Ask an Attorney app, where all the shows from the past, or many shows for the past few years, you can re-listen to those on the Ask an Attorney app on your iPhone. Thank you so much for listening to Ask an Attorney, all about Florida law. Hope you have a safe week, and go Bucks. Go Bucks tomorrow. Hope there's a huge victory there. You take care. Have a safe week. So long.